Welcome to this episode of People's Law. I'm your host, Bob Cocco. I've been a practicing lawyer for over 20 years in Philadelphia. Most of that time I've specialized in consumer protection law, an area of law that is not very well known to the general public, like, for example, personal injury law. But even with personal injury claims, there are many common issues that the average person is not sufficiently aware of that can severely limit or otherwise affect claims they may have. So because my goal in this show is to improve the average person's basic knowledge of the laws that most affect their daily life, we're going to have a guest from the legal community provide you with some useful information to protect your legal rights. If you or someone you know has a personal injury claim, whether it's in work or outside of work, and to discuss those matters, we'll hear from personal injury attorney Nick Renzi. Nick, welcome to the show.
Good evening, Bob. Thanks for having me.
Let's start out by having you talk about yourself a little bit. How long have you been a practicing lawyer?
I've been practicing law since November of 1991, both in Pennsylvania and New Jersey.
Okay, that's going to force me to do some math, but I think that's about 25 years, right? Or is
No, it'll be 28 years.
28, okay, you're better at math than I am.
Yes.
And all that time you've practiced in Philadelphia?
Philadelphia, surrounding counties, and South Jersey.
And in the area of personal injury law?
Personal injury law, yes, which encompasses also workers' compensation and Social Security disability.
Okay. And do you have a partner?
I have a partner, her name's Christy Adams.
Okay.
I'd like to do a little shout out to her.
Okay, good. So let's dive into personal injury law because it's something that's very well known to the public, but there, like a lot of things, there's nuances to it that people should be aware of that could help them if they find themselves in the unfortunate situation that they're injured. And one of the issues that pops up very regularly, I know in conversations we've had, is when individuals don't have enough insurance to cover them, particularly in auto accidents, which are the most common accidents that
Yes.
people are injured in, right? So I want to talk first about insurance coverage, and specifically in Pennsylvania, what's called limited tort coverage. So can you tell us first what limited tort coverage is?
Well, limited tort came about in the late 80s, about 3 years before I began practicing, and it was the insurance industry basically telling people that with this limited tort option, they could hold down their insurance premiums. But in reality, what it does is it limits people in their abilities to bring a lawsuit in the automobile realm. So here in Pennsylvania, you have limited tort. The equivalent in New Jersey is the verbal tort threshold or the limitation on lawsuit option. But in any event, for a lower insurance premium, you limit yourself in this situation in which you could sue. So in Pennsylvania, if you've chosen the limited tort option and you get in an auto accident, you come to me, I look at your auto policy and you believe you have what's called full coverage, totally different thing, full coverage as opposed to full tort. And I tell you you have limited tort, and in order for you to recover non-economic damages, which are the injury damages, which is the biggest part of your claim, you have to have a permanent loss of bodily function, and number two, you have to have it has to have a negative impact on your life, these injuries. So all of a sudden there is a hurdle to overcome in order to get you compensation.
Right, so let's break that down for the viewing audience and talk first about the permanent injury component to that. So what type of injuries would that involve?
Well, it's a permanent loss of bodily function, and that's a question of fact for the jury. So there's no concrete answer to that question. A jury has to determine if you have suffered a permanent loss of bodily function. If they do determine that, then they have to determine whether your life has been negatively affected.
Okay. And in your practice, that type of permanent loss of bodily function, would that be the most common sort of injury you'll see in whatever fact scenario, auto accidents or workplace injuries, or those are the less common sort of injuries that you'll see?
Well, again, I mean, I've had a case where the gentleman had a fracture of a forearm. It was non-displaced, and a jury found that that was not a serious injury. Permanent loss of bodily function is more Jersey terminology. Pennsylvania, it's a serious injury. And again,
Serious
another arbitrary term. To present facts to a jury and for them to find that, yes, this person has a serious injury with a negative impact on their lives. Jersey, much more severe, permanent injury, permanent loss of bodily function.
And is the standard in Pennsylvania, the serious injury standard, is that one that's hard to meet?
Yes, more so than if you had full tort, where a sprain and strain of your neck or lower back would lead to compensation. So it does make it more difficult for the consumer who has chosen, limited tort.
So how did the insurance companies convince people to take the limited tort option? It's a lesser insurance premium that they're given by the company. How much less on average would you say from your experience is the premium?
Well, here in Philadelphia, I mean, you're looking at maybe $300 or $400 more to have full tort. For some people, that's a lot of money, especially in this city, and so more people are choosing the limited tort option. And in the suburbs, you have insurance agents who are not properly educating their customers, because we're finding that some people in more affluent areas of the suburbs have chosen limited tort, which makes no sense at all.
They have no economic incentive, so it's just a matter of not being educated properly by their agent.
Because auto insurance is much cheaper in the counties in Pennsylvania than it is in Philadelphia.
So percentage-wise, for someone, say in Philadelphia, that $300 or $400 would represent what percentage of their total premium?
Well, let's say their premium's $800 or $900 for a basic policy, or $1,200, whereas if you chose limited tort, it would be $1,600 a year.
Okay, so but the savings severely impairs your ability to make a claim. Would you say that savings from what you've seen in the personal injury realm, does that savings translate into a benefit to them when a personal injury claim is filed?
Not at all. not at all. Quite the opposite.
Benefits the insurance company, though.
Exactly.
Okay.
Benefits the insurance company.
So, sticking with insurance issues for automobiles, another issue that sometimes arises is you're struck by a vehicle that doesn't have any insurance or might have a minimum policy. So let's talk about the kinds of insurance that would help a consumer when they're in that situation. Let's say with someone with no insurance, right? There's a certain type of coverage that you can buy for that.
Which is called uninsured motorist coverage. I mean, in Pennsylvania and in New Jersey, you have to have your car insured. That's a law, and you have to choose. You can choose minimum coverage, which is minimum liability coverage of $15,000 and $5,000 medical component, and you need no other coverage. You have to carry that minimum coverage, but you do need uninsured motorist coverage, which is coverage that you can get from your own carrier if the driver that hits you is uninsured. And then you need underinsured motorist coverage when you're hit by someone who has not enough coverage to compensate you for the injuries that you've sustained.
Is there a minimum amount of dollar coverage that you recommend to your clients to carry for uninsured motorists?
Well, my partner and I recommend that you carry the most that you can, because people sustain serious injuries and you need this extra coverage. So I think you need at least $100,000 at a minimum, just to have a chance to recover the amount of money that you need to compensate you for your injuries.
Right. So when you're buying uninsured motorist coverage, there's another type of coverage that's related to it, underinsured motorist coverage.
Exactly.
Do you purchase those two together?
I would, and I would highly recommend that.
Okay. So
I do on my own policy. And,
right, that's a good point to
and
make.
insurance agents should recommend these things too. Now, if people can't afford them, then obviously you can only buy what you can afford. But
sure.
you need these coverages. So we've seen many cases, more than you would imagine, where these people are severely injured and there's not enough coverage to make them nearly whole, again.
So
that's tragic.
Yes, absolutely, and that's why we want everyone out there to know how serious an issue it can be, that cost savings that they're experiencing in the long run may be doing more harm than good. So underinsured motorists may seem self-evident by the term, but that means that you're struck by a driver who has the minimum coverage or just maybe not sufficient to cover you in a serious injury situation.
Exactly. So, for example, you're struck by a guy who it causes you to sustain a compound fracture of your leg. You have a hospital stay. You have many medical bills. You have wage loss. And this gentleman only has, or this woman only has $50,000 in coverage. So we obtain that coverage for you, and then we look to your own underinsured motorist coverage to further compensate you because you have $250,000 or a $300,000 injury. So, and then we're relegated or limited to your whatever UIM coverage that you have.
Can you recall a specific incidence where you regrettably saw too little coverage for a client and had no recourse to underinsured or
Too many incidents. As a matter of fact, we're working on one now where a pedestrian was run down in a careless manner by a driver and sustained multiple injuries, including a lacerated spleen, which caused him to have the spleen removed, compound fracture of the leg, a torn anterior cruciate ligament of the other leg, which requires surgery, a fractured eye orbit. You know, we're talking about a $1 million and up case from an economic value.
Right.
Well, the gentleman that hit him only has $100,000. We're about to secure that coverage, and our client only has $15,000 in underinsured motorist coverage. So he's going to get $115,000 when he needs, you know, $1 million plus.
Yeah, and how often can you pursue the individual who struck your client from their personal assets to make up that difference?
Well, you know as well as I do, as a consumer protection attorney, there's the gentleman that only has $100,000 in coverage doesn't have much assets that we can attach, and it's not very easy to attach assets.
Yeah, true enough. I've certainly experienced that myself in my own practice. Okay, we're going to take a short break, and when we return, we'll talk to Attorney Nick Renzi about workers' compensation claims and also Social Security claims.
You know you watch. You shouldn't be watching this. You should be watching LaSalle TV. Hey, watch LaSalle TV. You know you watch.
Man, Keegan is taking this you know you watch thing way too seriously.
You know you watch LaSalle TV.
This is Kevin, and Kevin could use some kindness. Here's Ian. He could be that man. Ian chooses to be inconsiderate and not hold the door for Kevin, and in turn, Kevin suffers. Kindness may be a choice, but doing so is always the right one. So if Ian can make the right choice, you can too.
According to the Mayo Clinic, exercising has stress-busting benefits by bumping up your endorphins and improving your mood.
Welcome back to People's Law. I'm your host, Bob Cocco. With me is personal injury attorney Nick Renzi. to help us understand and discuss various personal injury topics. We're going to move on to workers' compensation and Social Security claims, but before we do, Nick, I wanted to wrap up our discussion of auto claims by, even though people may be familiar with some of the aspects of this, just to kind of go over what a protocol should be when you are in an automobile accident, what are the things you should do when that occurs. So I would imagine the first thing that you should do if you're in an accident is to make sure you're okay, the people in your car are okay, look at your car. What's the next thing that you would recommend that a consumer do in that situation?
Well, you want to call the police. Now, in Philadelphia, last year or so, the police will only come to the scene of an auto accident if there are injuries. So if there are no, let's say, substantial injuries, if there are no substantial injuries, the police are going to tell you to get the information from the other driver, and that's crucial. You do want to take a photo of the vehicles, especially the other drivers' or the license on the car. But then you want to take a photo of that person's driver's license and also maybe a photo of their auto insurance information.
Okay, so it's obvious why you would want their auto insurance information. Why would you take a picture of their license?
Well, in case it leads to a lawsuit, you want to know the identity of the person that you have to sue, because that becomes the defendant in your case.
May not be the same person who's the owner of the vehicle.
Exactly. Right. We don't know who's driving that vehicle, who has permission. Sometimes people will refuse to give you the information. In that situation, you must basically demand that the police come to the scene because the other driver is being non-cooperative. But the more information that you get at the scene, the more we can help it can help us to properly represent you.
When you tell the police that there's no serious injuries, but someone's refusing information, are they more responsive in those situations?
They will become more responsive.
Okay. All right. Well, that's reassuring.
Or they should become more responsive.
They should be.
Philadelphia, we don't know.
Yes, it's a work in progress. Having secured that information, obviously after that, the insurance company is going to contact the parties who are in the accident. Now, let's talk about statements that they may have to give to their own insurance company and to the opposing driver's insurance company. Should a consumer contact an attorney if they're injured, obviously? Should they contact an attorney before they give any statements at all?
Of course.
Yeah.
Even if they're not injured, if it's just a property damage claim, they should call an attorney just to get, find out what their rights are. We give a lot of information to people that call us without them retaining our services. There's really no fee for that.
Right.
But they need to know, again, what their rights are. They are obligated to give statements to their own insurance carrier if they require one. But they should have an attorney with them, at least on the phone, for that statement. They're never required to give a statement to the other person's insurance carrier.
Okay, so you can refuse that if you're
Sure.
contacted by the
And they
opposing-
should.
Okay, good. I guess we can move on. Is there anything else you wanted to wrap up in terms of procedures when you're in an accident?
I think we covered everything. Again, people should talk to their insurance agents and get the right advice about what coverages to have. They can call us, and we're happy to give people that advice.
Yeah, it's very important, and it's unfortunate that that insurance companies are penalizing sometimes the people who are least able to afford it with these limited tort scenarios that they've convinced the legislature to embrace, but that's the situation we have to deal with. So let's move on to another area of personal injury, as we discussed at the beginning, which is workers' compensation claims. So if you're hurt at work, what is the first thing that you should do?
Well, if you're hurt at work and you're able to, the first thing you should do is report the accident to a supervisor, because you have 120 days in Pennsylvania to give notice of your work injury. If you don't do that, within 120 days, you then could be barred from bringing a workers' compensation claim. So that's the first thing to do. And then the second thing to do would be to seek medical treatment if you need it.
Now, where do you seek that medical treatment from? Are you required under Pennsylvania law to seek it from the employer's doctors, or are you allowed to choose your own doctor?
You are required to seek medical treatment from the employer's doctors only if, at the time you're hired, your employer advises you that there's a list of doctors to choose from, and they have you sign a document stating that they told you about these doctors and you've reviewed the list. They must also do the same thing at the time you're injured. If they don't do both of these things, and a lot of people don't know this, the injured worker is able to go to his or her own doctor from the get-go. If they do give you this list and have you sign both at the beginning of your employment and at the time you're injured, then you are relegated to choose a doctor from the employer's list of doctors, and you must stay with that doctor for the first 90 days after the work injury.
So if the employer didn't provide that list of doctors that they should have provided, but the worker is unaware of the requirement you just talked about and goes with the company doctor, do they still have to stay with them 90 days?
They don't.
They
But
don't.
without
Okay.
knowing
Right.
what I'm telling you here,
Yeah.
they have no way of knowing this. A lot of
Unfortunately.
times, they're led to believe that they must stay with this doctor even though the employer did not follow the rules, so to speak. So again, it's very important that an injured worker call an attorney and find out what their rights are as this thing is unfolding.
Is every type of worker entitled to workers' compensation insurance, or is there only a certain type of employer that's required to give workers' compensation insurance?
Now, in Pennsylvania, it's the law. It's a state law. If you employ workers other than yourself, you must have workers' compensation insurance, and if you don't, it's a state crime.
Okay. In addition to workers' compensation claims, I want to also talk about Social Security claims, another very common type of claim, increasingly so it seems like. Let's talk about both types of Social Security claims. Why don't you tell the viewing audience what they are? And
Well, there's a lot of people get these confused. There's Social Security Disability, SSD, for people who have worked 5 years out of the last 10. So they've paid into the system, so to speak.
Okay.
If you've worked 5 out of the last 10 years and you're injured, disabled to the point where the criteria or the standard is totally disabled from any form of gainful employment, and that disability has lasted for or will last for 12 consecutive months. So if you have that situation and you've paid into the system, you're entitled to SSD. If you don't have those quarters in, then you're applying for supplemental security income, also known as SSI. Two different things under the same system, but two different things. SSI is needs-based, and they look toward assets. So if you have a spouse and there's a certain amount of assets, you are not entitled to SSI.
how about an SSI applicant? Is employment considered? Either the
SSI, you don't have enough quarters in. We have some supplemental security income clients that have never worked or have worked minimally.
What if they are working, have not paid in the past, but they're working now? Does the income they earn from employment affect their application for SSI? Will they have to stop working,
Again,
in other words?
it's 5 years out of the last 10.
Okay.
You have to have enough quarters in, so to speak.
And for SSD, how does employment of the applicant affect their ability to make that claim?
Well, again, if you've worked 5 out of the last 10 years and you're now unable to work, then hopefully your doctors that you're treating with, especially a specialist, is going to support your position that you're totally disabled from any form of gainful employment.
Okay, so talking about doctors, what kind of medical treatment do you have to show in each one of those claims? What kind of medical treatment do you have to engage in and have documented to make the claims?
Well, there are listings in this Social Security book, depending on what body part, also psychological. So if you come under one of these listings, the doctor has to fill out what's called these source statements to help you present your claim, for total disability, so to speak. So that works both ways, for SSD and SSI.
Do you have to initiate those claims with a lawyer, or can you do it on your own?
We encourage people to fill out an application at their local office or even online now. It's very easy to do nowadays. These applications can be filled out online. If the administration approves you, then you don't need us. If you're denied, then you should contact us because you only have 60 days to, in Pennsylvania, it's a two-step process: application, denial, request for hearing. State of New Jersey, even though it's all federal, it's still a three-step process, which Pennsylvania used to have: application, denial, request for reconsideration, denial, request for hearing.
After you have a hearing, how long does it typically take for the judge, the administrative judge, to rule on a claim? Is there an
Could
average
take
length?
anywhere from 2 to 6 months. That's what we're finding,
Okay.
you know, now.
One thing we could also talk about, if we've finished covering Social Security for now, is there anything else you want to add to that?
Again, a treating physician, preferably a specialist, will carry the day in order to present your medical reason for being totally disabled. Without that, it's almost impossible to win the case.
We have very little time left, but one issue I wanted to cover is slip and falls. What's the most important issue that consumers who slip and fall inside of a property or outside of a property should be aware of to protect their interests and their rights?
Well,
to
two
make that
things.
claim?
Number one, giving notice to the property owner, if that's possible, and also number two, contacting a lawyer, preferably us, as soon as possible. You referred us a very good slip and fall case. I mean, good by the fact that the poor gentleman was
Sure.
injured,
Yeah.
broken fingers with surgeries. We needed to put these people on notice immediately and ask them to preserve any videotape. We have a lot of videotape nowadays.
Right.
And if they don't preserve the videotape after us putting them on notice, we can get a negative inference charge against them if the case were to go to trial.
Great. So Nick, with the time left, why don't you let the audience know how they get in touch with you if they do have a personal injury claim?
Well, you could call us. We're Adams Renzi Law. That's the name of our firm, adamsrenzilaw.com. Also, nr@adamsrenzilaw.com, and 215-546-4208. We're at 1429 Walnut Street on the 14th floor in the heart of the city, and all consultations are free of charge.
Great. Thanks to Nick Renzi for appearing today. And if you're interested in discussing and learning more about the topics we covered or to contact our guests, you can go to my website, phillyconsumerlaw.com. And I'd like to thank our guest again for appearing today and thank you for watching. So until next time, remember, take the time to understand and protect your legal rights.